All rise. The lawyer of the apes is now in session. How's it going, everybody? I hope everyone is having a great weekend. The weather over here by me is really nice, so I'm hoping you guys have the same type of weather going on and you're enjoying your day. Wanted to take a break from my day, though, to get this video out to you guys. Today we got episode 10. Wow, I can't believe we're already at episode 10. That's great. Talking about hashtag Citadel censorship. Been seeing this a lot lately. Particularly, from Kat Stryker and her efforts to get the message out there regarding AMC and other issues related to AMC, GME, Citadel, and Robinhood. And the big word, that's going around from the documentation floating around is the word defamation. So we're going to talk about defamation in this video. But before I get started, just so you know, anything that I say in this video is legal commentary. It's not legal advice. Nothing I say in this video should constitute legal advice. We don't have an attorney-client relationship, me or any of you that are listening to this. I'm just giving you my opinion. And it's important to note that because, I'm in one state, right? And the law varies in every state in some way or another. So, this is a general overview about, defamation, and the state that you live in might have a slightly different set of rules. And in the law, even something slightly different can have a major impact on your case. So nothing I'm saying in here should be taken as legal advice. It's just a general conversation and commentary on defamation and how it may apply to this set of facts that are floating around on the internet. So basically, the first thing is, what is defamation, right? What does that mean? What is the definition of that? So under general state law, defamation is made up of 4 elements that can be said in one sentence. It is considered an unprivileged, false, published statement of fact about the plaintiff that causes harm to the plaintiff's reputation. So what that means is basically you make a false statement. So remember, the first element is falsity. It has to be a false statement. Without a false statement, then they don't have a cause of action. So there has to be a false statement. The second aspect of the elements is that it causes harm. So the person that is claiming the defamation has to establish some type of damages in order to establish that they have been hurt and that they're entitled to monetary compensation. Now, remember, that then delves into another type of defamation, which is called defamation per se. In defamation per se, they don't have to prove any actual damages because the fact that the statement was made, period, proves and establishes that they're entitled to some type of compensation. And remember, those are very specific. Per se pertains to making a statement about, a person's a loathsome disease, having a loathsome disease, spreading a rumor about somebody having herpes, for example. That could be considered a loathsome disease. Another violation of a per se would be, and this is the one that's coming up a lot, and this is the one that I'll discuss in more detail, is the idea of making a statement about someone that imputes them as to committing a crime. You can't make a statement that somebody is, responsible for committing a crime if it's untrue. If you make that type of false statement, that is a defamation per se. Now, this gets even more murkier, right? So there's 2 different types of defamation. There's libel and slander. Libel is defamation in the written form, meaning something you post on the internet, something you post on a blog, something you post on Twitter, something you post on Facebook, something you print in a magazine. Then there's slander. Slander is the spoken word, something you say to somebody else, something you say in a stream, something you say on television. So those are the 2 different types of defamation. It's broken down into 2 sections, libel and slander. One's written, one's spoken. Then you have to look at another aspect of the case. The other aspect of the case is, are you dealing with a private figure or a public figure? There's 2 different standards for private figures and public figures. And we'll get into that in more detail as we go along in the video. And that is a really interesting part of this entire thing, because the standard and the level of proof necessary to establish defamation between a private figure and a public figure is very, very substantial. So the big word that has been going around, lately on Twitter and on signs and in, on airplanes and various other forms of mediums. And remember, that's the written word. It's written, right? It's would be considered libel. That's the form of defamation it would be. We're talking about the word lie, right? Or liar, or the word lie. So the question is, have the courts ever dealt with this issue? Has there been a specific case that specifically dealt with the word lie? There's tons of other, forms of defamation and words that are said about people that wind up in court. But since we're dealing with a very specific word, is there any case out there? So basically, there is one leading case. The name of the case is Milkovich versus Lorraine Journal Company. So in that case, it involved a high school wrestling coach. And the wrestling coach, had some issues come up, and this newspaper, this local paper, this writer of the local paper published a piece on this situation going on with this coach. And this is what they said in the article. It is simply this: if you get in a jam, lie your way out. Anyone who attended the meet, whether he be from Maple Heights, Mentor, or impartial observer, knows in his heart that Milkovich and Scott lied at the hearing after each having given his solemn oath to tell the truth. Well, this sounds familiar, right? The whole idea of lying under oath, right? And that's exactly what was asserted in this article. This writer imputed that these two guys appeared at a hearing and they were sworn in and they lied, right? So basically, guess what happened? They took them to court. And what did they file? A defamation claim, and not just regular defamation, a libel claim, because it was written word, and libel per se. Why? Because it was lying under oath, which is a crime. It was a recognized crime in the state of Ohio where they were from. And because it was, he said it was a false statement, and it directly affected his time, occupation as a teacher and coach, and therefore he said he was entitled to damages. Now remember, he doesn't have to really prove too much in the way of damages because it was a per se violation. So what did the court do? What did the court say in this case? Did the court say that this was defamation by calling him, by saying that he was a liar and he lied under oath? The court said yes. The court said that yes, this was a form of defamation. So because this was a form of defamation, the case was allowed to go forward. And so here's what the court's rationale is. Let's talk about their rationale, because this is how we get some type of general idea about how and which way the court would rule if this issue came up, right? So the court said, first thing that's very important, because I see this on Twitter a lot, where people say, if I preface my statement with, in my opinion, or I believe, if you say that does that free you from possible litigation? Does that free you from a lawsuit? And the court said no. The court said, in my opinion, John Jones is a liar is no different than saying John Jones is a liar. Meaning, in one sentence, it had the words "in my opinion" in the front, and the other one was just that the person is a liar. The court said no, that is not enough to get you out of hot water. So that's really important to note. So just saying it's your opinion doesn't necessarily free you from the possibility of litigation. So that's a big thing. That's a big thing. So they said, all right, so how are we going to analyze this? How do we decide whether or not this statement that was made is a form of defamation? The court said, we're going to look at three factors. First thing they said is, was this a matter of public concern? And is it provably false, right? So listen to those words, that's important. Provably false. Were the statements that were made, can they be proven to be false? So remember, falsity has to be proven. And then on the other side, if you are charged, if an allegation or a filing of defamation is against you, truth, right, is a defense. So they're saying that it's false. But if you can prove as a defense that it's true, then obviously you could defeat the defamation claim. The second thing is the statements made, no reasonable person could mistake for a fact or imaginative expression or rhetorical hyperbole. Those types of statements cannot be actionable. So if it's hyperbole or just a form of imaginative expression or colorful statements, think about like a comedian, right? If a comedian makes a comment, a lot of the times they say crazy things, and they basically are saying, well, if no reasonable person would believe what's coming out of a comedian's mouth would be true, then that is not actionable. But if it's not that type of expression, then it could be actionable. And the third thing is, as a matter of public concern, a statement that reasonably implies false or defamatory facts regarding public figures made with actual malice can be actionable. So we're going to get more into that later. But remember, I told you there's a distinction between being a public figure and not being a public figure. And that's very, very important to remember. So basically, the court said, listen, the language that they set forth in the column did not sound loose, right? It wasn't trying to be funny. It wasn't like, loose. It wasn't hyperbole. It was a very straightforward statement that this person committed perjury, right? The court said in the decision, we think the connotation that petitioner committed perjury is sufficiently factual to be susceptible of being proved true or false. So basically, they're saying, look, this statement that was made alleged that this person committed perjury under oath, right? But that type of statement can be proven to be true or false, meaning based upon, if it went through the process, they could prove whether it was true or not. A determination whether petitioner lied in this instance can be made on core of objective evidence by comparing the petitioner's testimony before the association with his subsequent testimony before the trial court. So they basically said, this was defamation because the statements that were made in the article about the person lying on the oath could be proven to be false, and that it is not just straight opinion. So that's the difference. It cannot be just straight opinion. Anything that's straight opinion is protected. If it's not straight opinion, then it cannot be protected. But again, the word opinion, you have to be very careful about that. You can't just say, in my opinion. It has to be for a fact, an opinion that can't be proven otherwise. If it's something that can be proven otherwise, then there is a possibility that they can still be charged with defamation by somebody. So let's go over some other recent cases, right? So Cosby, that was a big one from not too long ago, right? Bill Cosby. So Bill Cosby was alleged to have, well, he was found guilty and then released, but at the time of this, he was alleged. At the time of this case, he was alleged to have, committed acts against women, right? So what happened was Hill was one of the individuals, Renita Hill. She was one of the women who came out against Cosby for what he did. And basically what happened was she filed a defamation lawsuit against Cosby's attorney, Cosby himself, and Cosby's wife. And at no point did any of these people actually say the word liar, right? They never used the word liar, but her assertion was that based upon what they said, you could have inferred very simply that she was being called a liar. Now, this is important in this case because remember I told you before that it's very specific from state to state about how to establish defamation, right? Well, remember I said before, generally defamation is like 4 elements. Well, in Pennsylvania, they have a 7-point test, right? So that shows you how important it is to know your specific state's law. And that's why, as I said before, nothing I say in this commentary is legal advice because it can't be. It's impossible. I can't give advice to anybody because everything varies on a state-by-state basis. And this is like that for the law. There's always like a general law, and then there's the very state-specific. So anyway, there were 7 elements in the Pennsylvania statute, and basically the comments were this: the attorney basically said that these statements are made up, they're absurd, she's being ridiculous, they make no sense. Again, she said that made her sound like a liar. Cosby said something very similar. And the wife basically said that, the Washington Post should vet the accusers better. That was the statements that were made. So she filed a defamation action. And what did the court do here? Well, the court said, no, these statements were not defamation. Why? So let's see what happened. The court said that the statements did not constitute provable or disprovable facts and constituted opinion, immune from liability. The court stated, this court does not find that Martin Singer's statement includes language which implies the existence of undisclosed defamatory facts about the plaintiff. As such, this court considers the Martin Singer statements to be purely opinion proffered by an attorney who, while actively engaged in the zealous representation of his client, did not cross the line and defame the plaintiff. So what they basically said was, look, the lawyers say this stuff all the time, right? Remember, you have to look at everything in the context of where and who is saying it. That's really what this boils down to. So look, at the end of the day, when a person is represented by a lawyer and they're at a press conference, what do you think they're going to say? Of course, they're going to say, my client is innocent. This other person is not telling the truth. That is just in the context of litigation. That is what happens. Now, I'm sure there are some things, if the attorney completely made an outrageous statement that would go above the reasonable type of statements that get made in the course of litigation, then the attorney could have been on the hook. But in this case, they said no. They said that this is just the general stuff that usually gets said. How about the other statements? The court held that the statements made in the paper lack the element of harm and simply encourage the public to draw their own conclusions. So basically, the statements that were made by Cosby that were published in Florida Magazine, they said that those statements that he was making were basically saying, no, listen, draw your own conclusions. You can't not allow people to make statements and then just basically invite people to make up their own mind. But again, you still have to be careful in the way you couch the terms. Saying opinion or I believe does not necessarily going to free you from that. So basically, the court said, even assuming the veracity of all that the plaintiffs have pled, the three statements do not support the claim for defamation under Pennsylvania law. So again, Pennsylvania law was the key there, right? All right, so that was one case. That's one recent case where they said, no, those statements are not defamation. So how about another case? Let's go into one where, spoiler alert, they did say that it was defamation. So I don't know if you guys remember this case, the Jerry Sandusky case that happened a few years back. Well, in that case, one of the coaches, Coach Boheim, he questioned the accusers. He basically said, that they were, that it was all made up, lies, blah, 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 et cetera, and so forth. And basically, they filed a defamation lawsuit against. And here's just some examples of what he said. This is alleged to have occurred 20 years ago. So we're supposed to do what? False allegations for a false allegation ? That was one of the statements. It was a question, but it was still found to be defamatory. For what I absolutely believe is a false allegation, I know Davis is lying about me seeing him in his hotel room. That's a lie. If he's going to tell one lie, I'm sure there's a few more of them. So basically, he went on and on and on, calling people liars. The court said a defamatory statement of fact is in contrast to pure opinion, which under our laws is not actionable because expressions of opinion, as opposed to assertions of fact, are deemed privileged and no matter how offensive, cannot be the subject of an action for defamation. So again, they're saying again that if it's your opinion, that you could say what you want to say, but you have to make sure that it is truly an opinion. The court said that these statements of him being of these other people being liars was not merely an opinion. And how did they determine it? What elements did they say? Again, they said, here are some factors that we have to consider. Is the specific language in question, does it have a precise meaning which is readily understood? Can the statements be proven true or false? Again, we're seeing that. And then whether the full context of the communication in which a statement appears in the broader social context, readers or listeners, that what is being read or heard is likely to be an opinion, not a fact. Again, so remember, you have to look at things in their totality, in the context of how they're being said, where they're being said, and when they're being said. So basically, so the court said this, With respect to the first factor, again, remember, is whether specific language has a precise meaning which is readily understood, right? Boeheim used specific, easily understood language to communicate that Davis and Lang lied. Their motive was financial gain, and Davis had made prior similar statements for the same reason. These are clear statements of the plaintiff's actions and a driving force for their allegations against Fine. Consideration of the second factor similarly weighs in favor of treating Boeheim's statements as factual because the statements are capable of being proven true or false, as they concern whether plaintiffs made false sexual abuse allegations against Fine in order to get money and whether Davis had made false statements in the past. Remember, so again, the court pointed out, even though he used the phrase, I believe in front of his sentences, that was not enough. They said the statements were not rhetorical hyperbole. They drew the distinction and they said, why? What was it about his statements? What did he know that other people may not have known? They said Coach Boeheim's knowledge of the case had access to the university's internal investigation and other documents and materials, which were generally unavailable to the public, suggested that he had additional or undisclosed knowledge upon which he spoke. So the court basically said, listen, this guy had special knowledge. He knew about certain things behind the scenes that other people wouldn't have known. So that was a big factor in that case, and that's important to consider. You know, if you have special information about something, then that could lead to you being possibly committing defamation because you know something the general public doesn't know. So basically that's the big thing. So remember, think about it. So if somebody calls someone a lot, says, like, for example, let's say somebody does a job for you and you go around saying the job was terrible, they did a terrible job, their work is garbage. That is a protected statement. That's your opinion, right? They did work for you and you feel it's garbage. But what if you go around on the internet, on Yelp or something like that, and you post a comment that basically says that company, not only do they horrible work, but they're scam artists and liars. That has actually been found to be a libelous statement. There was a case recently that found that calling a company a scam artist and a liar, that was sufficiently harmful to their reputation. And the court awarded some money in that case. And that wasn't substantial amounts of money. We're not talking hundreds of thousands of dollars, but there is some precedent that, going on, websites like Yelp or any type of place where you can, or TripAdvisor, or a place where you publish opinions about work or do reviews, you can be held liable if you make statements about general public individuals. Then there was another case that involved Courtney Love, and this was a Twitter case. She made a tweet on Twitter, and she basically had made an assertion that somebody that she knew was a drug user and lost custody of her child, et cetera, and so forth. Anyway, that person went after her and sued her for libel. It never went to litigation. It wound up settling. But again, but the fact that they settled it means that they definitely, to a certain extent, it was to get, not to drag it on and just to get it over with. And to its other extent, there was a potential belief by the lawyer that there was some, some strength to the case that could have, led to a problem, which would have been more costly to the defendant. So there's other situations that come up on the internet where the word liar, has been that has been found just to be, opinion. The courts have said, just generally calling someone a liar is just an opinion. There's websites out there where people can write things about, people that they don't like, or people that are their ex-boyfriends or girlfriends or whatever. Things get posted all the time on the internet. And again, like I said, it depends on what state you live in. Some courts find this to be, non-actionable, and some do. And again, they are always looking at the same thing, the context, right? Look at the full context of the statement. Does the language have precise meaning, and can the language be used to be proven true or false? Those are the big telltales, right? So basically, those are the general elements of defamation and, where the courts stand. And basically the answer is the courts are all over the place. The courts are just completely all over the place. They are just, there's no definitive way to say, so calling someone a liar is not going to get you in trouble, or it is. And at the end of the day, you should always err on the side of caution, right? Erring on the side of caution is always the common sense thing, because if you think about it, even if you can win, right, to be dragged into court, to deal with the expense and to deal with the aggravation and the frustration of all of it, it's just not worth it to a certain extent. That's why it's understandable why some people, wouldn't do certain things or run certain ads, because, they just don't want to deal with the headache. It can be very costly and time consuming, and some people don't want to get involved in that, which makes complete sense. So there's something that I do want to talk about, though, about the difference between a private figure and a public figure. So when it's a private figure, right, just like an average Joe, a regular person, that type of person does not have to establish much. It's just a regular negligence standard. You have to show that the person who made the communication that was libelous or slanderous, they just acted in a negligent manner. But if you are considered a public figure, right, you have to show something extra. You have to show what's called actual malice, which in the most simplest, basic, talking to like someone like they're in kindergarten definition is you lied on purpose to hurt them, right? You have to know for a fact that you're lying about them and that you're trying to hurt them. So that's actual malice. And for this situation, when you're dealing with someone like, Ken Griffin, for example, he is a public figure. He is out there enough where he's a public figure. So New York law, I'll talk about New York law in this regard, even though, again, he's in a different state. So again, this goes to what I'm trying to explain, that you have to be careful about the different types of law and different standards. New York, basically, he is considered a public figure. I mean, there's no question about it, and I'll show you why I believe that to be the case. But if it was in New York, they call it the vortex standard, right? So what is the vortex standard? The vortex standard means that the person puts themselves out there enough, they draw enough attention to themselves where they just get sucked in, like the vortex, into like a tornado. They get sucked themselves in, they get sucked into it because they just put themselves out there in such a way. So, I want to go now take a look at this letter. This letter came out a while back that Kat Stryker had posted regarding some of her planes and banners, but she posted the other day that a bunch more have gone out to a lot of these companies, and there's this cease and desist letters going around trying to censor the ape community from saying certain things. Now, this letter, it's important to note, remember, this said, the banner in this case was going to say Ken Griffin lied under oath. Now, again, remember, this is just a commentary, but if you think about everything I just talked about in this video, the statement Ken Griffin lied under oath, I mean, listen, the reality is that is 99.99% defamation per se allegation, right? And that is not something that you can really get around. That you can easily see them filing a lawsuit. Would they ultimately win? That cannot be predicted, right? And again, remember, remember, this is an actual malice standard. So even in a case like this, right? Remember, can it be proven true or false, right? Can the criminal allegation be proven true or false? Yes, it can, right? So because it can be proven true or false, it's, this is imputing a crime, right? So this is per se, and this is pretty serious. So this one, this letter where where the banner was trying to say Ken Griffin lied under oath, there is some potential for, an actionable defamation claim, because you're really talking about a crime. And look, I mean, there was a case. The case is almost directly on point at a very high level. So it doesn't matter, about the state law. And again, this was New York. This was at least in New York. This was going to be done in New York. I don't know where this company is located. I'm not sure. Doesn't say in the letter, actually, so I'm not really sure about that. But anyway, again, this is a lie under oath. So there's a big difference, though, between lying under oath and then just a general statement of lying. But again, you have to look at the context and how it's being said. And remember, is Ken Griffin a public figure? Well, let's look at page 2 of their letter. And up here, it just goes over why they're saying that, the whole lying under oath thing is untrue. But if you go down here, take a look, they cite a couple of cases, and look what cases they're citing to. Actual malice cases, right? So they know, right? They know that Ken is a public figure. So they know that the actual malice standard has to be proven. And look at the citations. Actual malice can be shown by evidence that a defendant was aware of the possibility of resulting harm, but nevertheless rushed to publish serious charges without a thorough investigation. So here again, there's an allegation in here that the sign was going to say under oath. So they're saying to the company, hey, look, if you don't investigate this and check into this, there is some possibility for some trouble. They're not wrong there. But again, the important part here really is the actual malice standard, because that is a much higher standard to establish. Courts have upheld findings of actual malice when a defendant failed to investigate a story weakened by inherent improbability, internal inconsistency, or apparently reliable contradictory information. So again, here they're saying, look, everyone's going around saying that Kenny G lied on their oath, but we have some other evidence here that can contradict that. Whether or not we want to believe this other opposing contradictory evidence is true or not, that doesn't matter. That's not what the court standard is. Our feelings, the courts don't care about what our feelings are. The questions are, can the statement that's being made be proven to be true or false? At this time, there is no proven fact that Ken lied on their oath. So because of that, you cannot make that type of statement without having some type of possible defamation claim hanging over your head. So this letter, you have to be really careful about. So this one, I can understand. Now, my understanding is that the other letters that went out, I'm not sure. I haven't seen the other letters. I don't know if the other letters are trying to claim that the other statements. I don't know if it's still the Ken Griffin lied on the oath statement. If all they're hanging their hat on is the Ken Griffin lied on the oath statement, then that's one thing. But remember, this isn't legal advice that I'm giving you. But if you look at the cases, my commentary would be, if you look at the case law that we just went over, right, and you look at the actual malice standard, the generalized statement, right, of Ken Griffin lied, right? Remember, to be proven that statement is defamatory, you have to prove that they have to prove that it is a false statement. Ken Griffin lied. So that's just a general statement. Ken Griffin lied. There's no context to it, right? No one is saying Ken Griffin lied, and this is why I believe so. And you cite to a bunch of factual allegations that could be proven otherwise. You're making a general statement, right? And then on top of that, because he's a public figure, you have to prove actual malice, which means you are purposely lying. You're purposely lying about calling him a liar, and you're doing it to hurt him. Now, again, how are you purposefully lying about calling him a liar? If it's your opinion in general that he's a liar, and you're not, but in the back of your mind, you're purposefully saying to yourself, I know he's really not a liar, but I'm going to call him a liar anyway because I want to hurt him. Like that's actual malice, right? That's the actual malice standard. So I'm not really sure what's floating around out there right now. My general opinion and my argument would be that that's not an actionable offense. I don't believe that's defamatory. That's not advice. That's just my commentary on the issue. Again, remember, everything varies from state to state. So you would have to really check with, counsel at that level. But my general legal commentary is that that is not something that is a defamatory statement. That I don't think that statement is being made that you're lying about him lying on purpose. You have a belief that he lied about something, and it's not related to it being under oath. It's just a general statement that lie. Look, everybody, listen, at the end of the day, let's be honest with ourselves. Everybody lies, right? Everybody lies, but not everybody lies on their oath. Not everybody lies to achieve a nefarious goal. Not everybody lies to, get one over on people. Just everyone lies. Everyone lies in general, right? So that's the thing to think about. Like, you have to remember the context, what it all leads to, and that's important. You have to remember that the context. You have to look at the big picture overall. So that's why a lot of times when people have asked me specific questions, I can't give specific answers because the reality is that everything varies from state to state. And I can only speak in generalities and give legal commentary, just like lawyers do on court TV or when they make appearances on television shows like CV Payne. I'm available anytime, CV. Charles, let me know. Anyway, so basically that's that. And the other thing that people have asked me a lot about is this. And this is interesting, and a great idea. I thought it was a great idea, but unfortunately it doesn't work. And I'll tell you why. So people said, how about this? We want to do something and fly something on a plane, put something on a banner. Can we petition the court and make a motion for declaratory relief? Can we ask the court and say, listen, we want to run this language on a sign, but we don't want to run the risk of possibly being sued for defamation. So can you let us know whether or not this statement is possibly defamatory? And the answer to the question is no. The court will not do that. The Supreme Court held that this is not something that is within the power of the courts. So basically, in this case, MedImmune versus Genentech, the Supreme Court reiterated that a court cannot entertain a declaratory judgment act lawsuit where there is no case or controversy pending, right? And I've said this before, an advisory opinion about an affirmative defense it might use in some future litigation. So remember, they're trying to say, listen, I want you to tell us that this statement is true because truth is a defense in the future litigation. The court said no. And here's a bunch of other cases they cite to. Again, advisory rulings on the potential success of defense before a cause of action is even accrued are not permissible. Dismissing a suit that attempted to gain litigation advantage by obtaining an advance ruling on affirmative defenses. A party to a declaratory judgment act case cannot ask the court to enter an opinion advising what the law would be upon hypothetical facts. So basically, in this case, this Thermalife case, the court said because Thermalife essentially seeks a declaratory judgment that its defenses would be meritorious if it is sued by BPX for defamation, or as a way to head such a claim off at the pass, Thermalife seeks an impermissible advisory opinion on a matter that is not ripe. Accordingly, Thermalife's claim for declaratory relief is due to be dismissed. So again, the courts have clearly said that you cannot move the court by declaratory motion to determine whether or not a statement or defense that you're going to have for a litigation is viable or not. So unfortunately, that is not on the table. So anyway, guys, listen, be careful with what you say on the internet. I mean, that's just, a general rule. You just have to be careful with what you say and remember in what context you say it, not only with this situation with AMC and GME, but just in life in general. It's very easy to be on the internet and to just fly off the handle and say whatever and then think to yourself, oh, I'll delete it or I'll get rid of it. What's on the internet is there forever. Now, remember, that doesn't necessarily mean that the person you say something against is going to wind up suing you, right? There's no definitive answer on that. That doesn't just because you make a statement that may or may not be defamatory, that doesn't mean that a person is actually going to ever go after you on it, right? But again, like I said, that risk is always very, it depends on how risk averse you are. And remember, you should never take that chance, at least without, directly consulting a lawyer about whether or not they believe, there has a viable chance of success on the merits. But again, even if there is an unlikely possibility of success on the merits, the other thing you want to keep in the back of your mind is, do you want to have to deal with the hassle of being dragged into court by somebody that has unlimited funds that can really make your life miserable? So again, and then the other thing is, in regards to that, you can seek declaratory relief, but let's say for argument's sake, the law firm did sue you for defamation, but you don't want to get dragged to court because you believe that the statement you made is not defamatory. There's what's called anti-SLAPP statutes in varying states. Not all states have anti-SLAPP statutes, but basically they allow you to, once the lawsuit's filed, you can file an anti-SLAPP motion, which will, and in that case, then the court will help determine whether or not there's a possibility of success on the merits for the defamation claim. So you don't have to go through all this crazy stuff. But again, that is also on state-by-state basis. So you have to be really careful and look into your specific state law. So anyway, guys, I hope this video was helpful. I hope it spelled things out a little bit more for you. You know, at the end of the day, you know, Citadel is really, you know, trying to, you know, censor people, but some of it, some of their censoring is not protected speech. So remember, there in censorship, right? There's certain things that are not protected. So if the speech that you're trying to set forth is a form of protected speech, then what Citadel is doing is trying to censor you. But if what you're trying to say is not a form of protected speech, and defamation per se are not forms of protected speech, then it's not censorship. But from what I've been seeing, that first letter, you know, there was some viability to it, right? You know, that's the reality. Citadel's lawyers had some valid argument to make because of that under oath. But again, if they're just trying to, you know, prohibit and censor, you know, general posts about AMC or To the Moon or GME this or AMC that, or ban dark pools or ban certain types of PFOF, you know, that type of stuff is protected speech. Obviously, there's nothing that's defamatory about that stuff. So, you know, you really have to be careful and, you know, be careful about what you say censorship is, because, you know, censorship is a confusing thing. You know, remember, it depends on whether or not a company is private or not. And if you're making statements on a public domain, they can take your rights away from you because they're a private company. Private companies can silence. Unfortunately, that's not a First Amendment protection. You know, Twitter and Facebook, they've done it. We've seen it be done. And they do it arbitrarily, which is ridiculous. But again, there's really nothing you could do about it. It's not a First Amendment violation. As a private company, they can pretty much do what they want. The state can't silence you, but a private company like Twitter can. So be careful with what you're saying is a violation of a First Amendment right. So anyway, guys, I hope the video was helpful. If you have any questions, feel free to drop them in the comments. Please subscribe. That would be great. And like the video if you enjoyed it. Until next time, guys, and I will be back at some point either tomorrow or Monday with the go over of the motion to dismiss that was filed by Robinhood in the MDL litigation. Until that, guys, have a great rest of your weekend. And for now, the Lawyer of the Apes is adjourned.